We start in the US, where Donald Trump has been found guilty on all counts in his hush money trial. This makes him the first former US president to be convicted of criminal charges and the first major party candidate to run for office as a convicted felon.
This was a disgrace. This was a rigged trial by a conflicted judge who was corrupt. It's a rigged trial, a disgrace.
We need to talk about the trial of Donald Trump. If you're clicking on this video, then you already likely have strong opinions about Trump. Maybe you hate him. Maybe you love him. Tonight, I'll try to bring you the facts of the case, as well as the external circumstances which surrounded the trial and is bringing into question the legitimacy of the ruling.
Donald John Trump.
Don't choke.
Is a convicted felon. Now, yesterday, a New York jury found him guilty on all 34 counts of falsifying business records in order to hide a sex scandal that would hurt his 2016 presidential campaign, and that's what the problem was.
The charges surrounding Trump stem from the known falsification of business records to cover up a crime. The New York prosecutor's office is hinging all of their charges upon two things. First, being that Trump knew about the transactions being examined, and that the transactions being examined facilitated a crime. Now, all of this is focused on the Stormy Daniels legal case. The prosecution points to Michael Cohen, known as Trump's fixer, who is known to have arranged the payments to Stormy Daniels on behalf of Trump.
Having something to do with paying some Stormy Daniels woman $130,000, I mean, which is going to turn out to be perfectly legal. That money was not campaign money. Sorry, I'm giving you a fact now that you don't know. It's not campaign money. No campaign finance violation. So
they funneled it through the law firm.
Funneled through the law firm, and the president repaid it.
Oh, I didn't know he did.
Yep.
There's no campaign finance law.
Zero.
So the president.
Just like Sean.
So this decision
Sean,
was made by.
Everybody was nervous about this from the very beginning. I wasn't. I knew how much money Donald Trump put into that campaign. I said, $130,000. He's going to do a couple of checks for $130,000. When I heard Cohen's retainer of $35,000, when he was doing no work for the president, I said, but that's how he's repaying. That's how he's repaying it, with a little profit and a little margin for paying taxes for Michael.
But do you know the president didn't know about this? I believe that's what
he didn't
Michael
know
had
about
said.
the specifics of it, as far as I know. But he did know about the general arrangement that Michael would take care of things like this.
After a reported 2-minute conversation with Donald Trump, Michael Cohen went on to establish Essential Consultants. This shell company was used for the purpose of facilitating the payments to Stormy Daniels and keep the nature of the transaction off the books. Further, it points to the National Enquirer, which had been preparing to publish the Stormy Daniels allegations. The National Enquirer admitted that it entered into an agreement wherein it made a payment to Stormy Daniels to ensure that she did not publicize damaging allegations about Trump before the 2016 elections. The transaction occurred directly through Michael Cohen himself to Essential Consultants, the shell company, and then to the National Enquirer, which finally brought it to Stormy Daniels. This was all out of pocket at the time. Then Michael Cohen agrees to receive $420,000 from the Trump Organization, which would cover the associated costs, taxes, and provide his payment for services. This was processed over the course of 12 payments as individual $35,000 payments. Each payment would be marked as legal services. The New York prosecutor's office would allege that by noting these payments as legal services, that it was a falsification to hide the true purpose. While the Trump defense team would argue that as this was a normal action by Michael Cohen as Trump's lawyer, then the definition of legal services was accurate. Regardless of whatever misleading hype that anyone might be telling you, the entire New York case surrounds the hush money payments to Stormy Daniels. Did Trump know about it directly? And, more importantly, did the payments do anything illegal?
President Trump says he paid Stormy Daniels $130,000 to stop her from spreading lies about him ahead of the 2016 election.
Mr. Trump and his lawyers say no campaign finance laws were violated. CBS 4's Hannah Doba is in New York with the story.
President Trump is now acknowledging that he paid money to adult film actress Stormy Daniels, though he denies they had an affair. In a series of tweets, the president described the non-disclosure agreement with Daniels as being very common among celebrities. Mr. Trump said it was intended to, quote, stop the false and extortionist accusations made by her about an affair.
Now, Trump admitted that the payments occurred. Trump and his lawyer, Rudy Giuliani, had been more ambiguous on whether Trump knew the details prior to Cohen opening Essential Consultants, and did indeed argue that the recorded 2-minute phone call between Trump and Cohen was insufficient time to establish that Trump was aware of all of the details of the payment. Whether or not Trump did indeed know about the details of the payment on the phone call, we must now address whether the payments occurred for the purpose of a crime. The purpose of a crime is perhaps the most important part of the case. That is because, under New York law, when prosecuting for falsification of business records, to raise the bar from misdemeanor to felony, then you must prove that the falsification occurred specifically for the purpose to cover up a felony. Which brings us to federal campaign finance law. The Department of Justice investigated then President Trump regarding the hush money payments and whether they constituted a crime. At the time, federal prosecutors dropped the case.
Hi, I'm Hans von Spakovsky. I'm a senior legal fellow at the Heritage Foundation, but I also spent 2 years as a commissioner at the Federal Election Commission. That's the federal agency responsible for enforcing the Federal Election Campaign Act, which regulates how candidates for federal office raise and spend money. The supposed campaign finance violation that the U.S. Attorney's Office in New York is claiming is actually not a violation of campaign finance laws. Here's why. In order for the rules to apply, it has to be a campaign-related expense. The Justice Department only once before has tried to claim that these kind of payments are a campaign-related expense. That's when they attempted to prosecute John Edwards. Remember that case? Contributors to John Edwards actually paid money to his mistress, who actually was working for the campaign and had his child. A jury did not believe these were campaign-related expenses, and in fact, John Edwards had 2 former commissioners of the FEC there to testify these were not campaign-related expenses. In fact, when the FEC audited his campaign, the agency itself concluded these were not campaign-related expenses. So this really is not a problem for the president, even though Michael Cohen is pleading guilty to this, because the U.S. Attorney's Office is basically being over-aggressive on this issue. If you take their views to its extreme, it would mean that any time a candidate pays off a legal claim against it, that's a campaign-related expense. Well, if that's the case, remember in 2017 it was reported that members of Congress have paid over $17 million to pay off almost 300 claims made against those members of Congress for sexual harassment and other claims like that. If the U.S. Attorney's Office is right, then all of those would be campaign-related expenses. Why? Because those payments were meant to silence the people making the claim so that the candidates would not be embarrassed.
Now, this brings us to the defense's claim of selective prosecution. Selective prosecution is the claim that justice is being done unequally. In this case, a discriminatory intent against a particular individual, Donald Trump himself. First up is Alvin Braggs, the Manhattan District Attorney.
Look to what I have done. So when I was at the Attorney General's office, I led the team that held Trump and his children accountable for their misconduct with the Trump Foundation. I oversaw the work which sued his administration more than 100 times for family separation at the border, the Muslim travel bans, trying to have a citizenship question on the census. Certainly throughout my career, I've gone wherever the facts have taken me. And the types of allegations that have been reported publicly, valuation of assets, perhaps the use of shell companies, tax fraud. I've done all these sort of cases. I've tried a mortgage fraud case. I've tried one of the most significant money laundering cases out in the New York region. So of all the candidates, I sort of stand at the ready with all the tools in the toolkit. And I've overseen some of the most high-profile cases to be litigated in recent years, ranging from the Trump Foundation case to our civil lawsuit against Harvey Weinstein for having a hostile work environment.
Similarly, Juan Merchan, the judge presiding over the Trump case, has been targeted. Merchan, who has been a New York appointed judge since 2009, was noted as having made several small-dollar donations to President Biden, as well as the Act Blue Democrat Super PAC. This is despite New York ethical guidelines saying that judges should not endorse political candidates. The Trump defense team further pointed to Merchan's daughter, Lauren Merchan, who provides legal services for high-profile Democrat candidates and Democrat organizations. Among those is Representative Adam Schiff, who led the Trump impeachment campaign and who has been utilizing the ongoing hush money case as part of his fundraising efforts, which has seen him raise more than $90 million. We have established that there is plausible facts surrounding the possibility that members of the judicial team might be compromised in their efforts. And with this, we have reached the end of the facts surrounding the Trump conviction. There are a great many other surrounding facts which Trump defenders can point to, including the numerous prosecution attempts which have required passing legislation specifically targeted at allowing retroactive prosecution of Trump, as well as several state attempts to remove Trump from the electoral ballot this November. All of this is argued as a wider concentrated effort to corrupt the electoral process through the judicial process. But here and now, we will not be going into those. Instead, we will leave it to the facts surrounding this case specifically. I know that if you are already feeling strongly about the political candidates this year, then your perspective on the trial is set in stone. Despite that, I want to ensure you have everything you need going forward. We are entering into an unprecedented situation where a sitting president might be running the country from the jail. Some people have wrongly mentioned that Trump, when elected, will be capable of pardoning himself. That is absolutely not true. Presidential pardon powers only exist with respect to federal crimes. So there's a real possibility of a future where a spiteful Democrat New York establishment might choose to disallow President Trump from leaving prison to perform his duties, and so we'll be in a truly weird world. Let me know down in the comments. Was the Trump case accurately prosecuted? Or was it corruption of justice where the verdict was decided before the case began? With all metrics pointing to Donald Trump winning an election in November, if he is elected, what will happen should the New York governor refuse to pardon President Trump? Like, comment, subscribe, follow the socials, and I will see you next time.